Beneficial ownership. So I know that when we speak about beneficial ownership, everyone sort of clenches and feels a bit stressed. But today we're going to take you through what does Public Communication 59, Public Compliance Communication 59 ask of us? What does beneficial ownership mean? Who is this warm body, this natural person that we need to look for? And what do you need to do as an accountable institution? So this three-step process, what is that three-step process? It's called the process of elimination. What do you have to do when you're following the three steps in order to find that warm body? So before we bring it home to South Africa and before we bring it home to PCC 59, so I'm going to refer to Public Compliance Communication 59 as PCC 59. We had to look at the FATF recommendations relating specifically to beneficial ownership. So FATF is the Financial Action Task Force. It's the international standard-setting body for anti-money laundering, for counter-terrorist financing, and for counter-proliferation financing. So we needed to know what is expected of us. What do we need to achieve in order to have a strong beneficial ownership regime in terms of AML, in terms of CFT, and in terms of CPF? So in terms of anti-money laundering, counter-proliferation financing, and counter-terrorist financing. So we look specifically at recommendation 24, which deals with the transparency and beneficial ownership of legal persons. It says that countries should assess the risks of misuse of legal persons for money laundering or terrorist financing and proliferation financing and take measures to prevent their misuse. Countries should ensure that there is adequate, accurate, and up-to-date information regarding beneficial ownership that can be obtained or accessed rapidly, so as soon as possible, and efficiently by competent authorities through either a register of beneficial ownership or an alternative mechanism. Countries should not permit legal persons to issue new bearer shares or bearer share warrants and take measures to prevent the misuse of existing bearer shares and bearer share warrants. Countries should take effective measures to ensure that nominee shareholders and directors are not misused for money laundering or terrorist financing. Countries should consider facilitating access to beneficial ownership and control information by financial institutions and DNFBPs, designated non-financial business professions, undertaking the requirements as set out in recommendations 10 and 22. So in summary, what is expected of us as a country and as an accountable institution, what is expected of you? So here we need to make sure that we don't allow the misuse of legal persons. So there must be transparency. We must know who our beneficial owner is. We must understand our beneficial ownership of our client, whether that is a lateral person, whether it's a legal person. If it involves a complex structure, we need to be able to untangle and deconstruct that complex structure to understand and pierce the corporate veil and to understand who is behind this structure, who is ultimately benefiting from the structure or deriving some benefit or ultimately controlling the structure. And of course, we need accurate and up-to-date information, and that's where the SIPC's beneficial ownership register comes into play, but we will discuss that in a minute. So now that we understand the international framework, we understand what we are trying to achieve. So we're trying to achieve preventing misuse, we're trying to achieve transparency, we're trying to achieve accurate and up-to-date information. What did we do as a country? So I'm sure everyone is familiar with the General Laws Amendment Act that came into effect on the 31st of December 2022. So one of the amendments that took place through this piece of legislation was an amendment of the definition of beneficial ownership. So in terms of Section 21B specifically. And Section 21B sets out the obligations relating to beneficial ownership. And here the amendments that took place involved the look-through principle. So it was amended to include every natural person who is a beneficial owner of a legal person, trust, or partnership. So we're identifying a whole range of role players through these amendments. And I'm going to take you through these amendments now. So the definition of a beneficial owner, of that warm body in terms of the Financial Intelligence Center Act, was amended through the General Laws Amendment Act. And the FIC Act defines beneficial owner now as meaning a natural person who directly or indirectly ultimately owns, exercise effective control of a client of an accountable institution or a legal person, partnership, or trust that owns or exercises effective control of the client of the accountable institution, or exercises control of a client of an accountable institution on whose behalf a transaction is being conducted. And in terms of specifically legal persons, partnership, and trust, each natural person contemplated in those subsections. And I'm going to take you through those natural persons in a few slides. So what is or who is a legal person? The FIC Act defines a legal person as any person other than a natural person, so not an individual, not a warm body, that establishes a business relationship or enters into a single transaction with an accountable institution and includes a person incorporated as a company, close corporation, foreign company, or any other form of corporate arrangement or association, but it excludes a trust, a partnership, or a sole proprietor. So of course it would exclude a sole proprietor because that is a natural person. It's a warm body. A trust and partnership are different structures in their own right. So we've been mentioning the General Laws Amendment Act, right? And it brought about the amendments to the definition of Section 21B, which is the governing section relating to beneficial ownership. And because of that amendment, and because there was general awareness needed on beneficial ownership through the findings of the Financial Action Task Force, through their mutual evaluation report, we needed new guidance. We needed specific guidance relating to beneficial ownership, and this resulted in the issuance of Public Compliance Communication 59, which was published on the 8th of August last year. So it was driven by general awareness on beneficial ownership, so general awareness relating to the accuracy and transparency of beneficial ownership. What is required in terms of the new amendments of Section 21B? It was driven by aiding with industry interpretations, supervisory body requests, updates to the FIC Act through the General Laws Amendment Act, as I've mentioned, and as I've mentioned, the mutual evaluation findings by the Financial Action Task Force. So when we look at beneficial ownership, and this is included in PCC 59, and that's why we're discussing it today, there's a difference in concepts between legal ownership versus beneficial ownership. So a natural person may be considered a beneficial owner on the basis that he or she is the ultimate owner or controller of a legal person through his or her ownership interest or through exercising ultimate effective control. A legal ownership by distinction means a natural person or legal person who owns the legal person through that legal provision. So a legal owner is not always the beneficial owner, and an easy example is that of an unlisted company. So when you look at a PTY Limited, the legal owner is generally those that own your shares, so it's your shareholder. But a legal owner could be a company. So a company could be a majority shareholder or your shareholder that owns more than 5%. But a company is not a warm body. A company is not a natural person. So a company cannot be your beneficial owner. So we need to understand legal ownership versus beneficial ownership. So for example, we've included this example here. Legal person B is your client and legal person C, which is a company, is 100% owner of legal person B. And legal person C, therefore, is the legal owner of your client, but cannot be your beneficial owner because, as I've mentioned previously, a beneficial owner is always a natural person. It's always a warm body. You can have more than one natural person as a beneficial owner, but you cannot have a legal person as a beneficial owner. So you need to look through, use your 3-step process of elimination, and I will come to it in a few slides, but you need to look through legal person C. You need to look through that majority shareholder and understand who is behind that legal person C, who ultimately derives benefit from legal person C, who ultimately exercises effective control of legal person C. And that natural person is not only the beneficial owner of legal person C, but ultimately owns your client, legal person B. So I hope that example draws the distinction between legal ownership versus beneficial ownership. So Section 21B, we've been mentioning it. What does it entail? What does it require from us as accountable institutions. So it relates to ownership and control structure. So it specifically requires you to understand the nature of your client's business as well as the ownership and the control structure of your client. So you need to establish the ownership and control structures of your client. You need to obtain information on the different types of ownership interests and the persons who owns that interest in your client. So if it's a complex structure, if it's a structure involving multiple companies, you need to look through those companies and obtain information on the beneficial ownership or on that ownership structure of those companies involved in the client structure. You need to also have an understanding as an accountable institution of the different types of risk and the different types of legal persons that can be involved in a structure, the manner in which these legal persons are created, because that will dictate the risk and also dictate what information you need to obtain. So for example, if you have a client that's a PTY Limited versus a client that's a nonprofit company, you would require different types of information from these two clients to determine the beneficial owner, to determine the ownership structure, and to also understand the risk that those structures pose in terms of beneficial ownership. So as an accountable institution, what is required of you is that you should understand different types, forms, and basic features of your legal persons, trusts or partnerships onboarded as clients or potential clients, the manner in which these legal persons, trusts, and partnerships are created, how to obtain beneficial ownership per client type, to identify or determine the possible types of beneficial owners each client type could have. And that's where your understanding of how each client type is created, how each legal person is created, how each partnership and trust is created will come into play, and how to identify the money laundering, terrorist financing, and proliferation financing risk posed by each client. So when that client walks through the door, what risk are they bringing? How do I mitigate this risk? How do I identify the warm body for this client? So I've been mentioning the process of elimination, so let's look at it, right? So in terms of Section 21B, it gives us a 3-step process. So we use these 3 steps, step 1, step 2, step 3, to identify who is my warm body, who is the ultimate beneficial owner, who ultimately derives benefit from this structure, from my client, who ultimately either exercises effective control or either oversees the management of the day-to-day operations of my client. So you need to look from step 1. So you begin at step 1, right? So you need to identify the natural person who independently or together with another natural person, they own the controlling ownership interest in your client. If you can't identify a warm body, there's no person who meets the threshold of 5%. There's no warm body when you look at the client that meets that controlling ownership interest, that there's no one who owns that. You move on to step 2. So if you have doubts about whether a natural person owns the controlling ownership interest, or there is no natural person who owns the controlling ownership interest in your client, then you move to step 2 and you identify the natural person who exercises control by other means. And in PCC 59, there's a non-exhaustive list of what control through other means looks like. So what could it entail? So it could be through a nominee arrangement, it could be through a power of attorney, so it could be through various other legal instruments that they're exercising control over your client, either a legal person, a partnership, or a trust. If you've gone through step 1, right, and you haven't identified, or there was no legal natural person who meets threshold of 5%, and you moved on to step 2, and you still couldn't find someone who exercises control through other means of your client, you move on to step 3, which is the final step in the process of elimination. So you need to exhaust step 1 and then step 2 before you move on to step 3. If no natural person is identified at this juncture, at this stage, then you will identify the warm body, the natural person who exercises control over the management of your client. So who is that person who runs the day-to-day affairs, who's making those executive decisions? And depending on your client, depending how the client has been structured, that person could have a different title. It could be a CEO, a COO, it could be a director, it could be a non-executive director. It would all depend on the structure of your client and the basic features of your client, which is what was explained in the previous slide, and which is why it's so significant to understand your client and the basic features of your client. So this is just a diagram that explains the process of elimination as set out in section 21B. I'm going to go through the 3 steps one more time. So first step, you look at controlling ownership interest. Is there a warm body that owns 5% or more of controlling ownership interest in your client? Remember, there can be more than one beneficial owner, but it can only be individuals. It can only be natural persons. If there's no natural person who owns controlling ownership interest in your structure, or if there's a doubt about the structure, then you move on to step 2. Step 2 looks through the structure and looks for the natural person who exercises control through other means of your client, over your client, sorry. Whether your client's a legal person, a partnership, or a trust. If you can't see that there is a natural person or warm body that exercises control through other means, then only do you move to step 3, which is the final step, and that is control over the management of your legal person, control over the management of your client. So let's look at each step individually. So step 1 looks at controlling ownership interest. So this is the natural person who through their controlling ownership interest in the legal person exercises influence over the decisions taken by the legal person and over the operations of the legal person. It can be determined by percentage of ownership interest of the natural person that the natural person has in the legal person, and the level of influence or control that the person can exercise over the legal person. So what do we mean by controlling ownership interest? Controlling ownership interest is the ability of a natural person by virtue of ownership interest in that legal person, so in your client, to control and or to take decisions regarding or influencing the resolutions, decisions, business operations of that legal person. So it's important to note that there is a change. So it used to be in guidance note 7. It used to be a 25% threshold, but with the advent and with the issuance of PCC 59, the threshold is now being updated to 5%, and we look at the 5% controlling ownership interest in our clients. So where did we get the 5% from? So it was driven by South Africa's exposure and the trends of abuse that has been noted of legal persons. So remember in the very first slide when I took you through the FATF recommendations, one of the main objectives or one of the main drivers is to prevent abuse of legal persons. So bringing into play the 5% threshold will prevent, or we have noted is low enough and is sufficient enough to prevent abuse of legal persons. It also brings it in line with Regulation 32A of the Companies Act, which is another piece of legislation that was amended by the General Laws Amendment Act, and which brings into play the Register of Beneficial Interest of Natural and Juristic Persons and discrepancy reporting. If you note that the 5%, when you apply the 5% and you note that the ownership interest is too dispersed, too diluted, then you move on to the next level. So you move on to step 2, and then if needed, you move on to step 3 of the process of elimination. Please take into account different ownership rights that could be into play in your legal person and your client. Maybe there are different ownership rights that carry different weightings, different voting rights. Maybe there are coalitions or agreements that are into play. So it's very important to obtain information that will help you understand not only the basic legal features of your client, but what is at play in terms of ownership rights in your client and with respect to your client. The 5% threshold can be less if the circumstances demand so, right? So if there's a higher risk of money laundering, terrorist financing, or proliferation financing, if you're a natural person, so you see that your warm body is a foreign politically exposed person, and we will be discussing politically exposed persons in a few slides. high-risk domestic politically exposed person or a high-risk prominent influential person, if there's significant adverse media on the natural person, if that client or the person has been subject of numerous regulatory reports submitted to the FIC. So yes, the 5% is low enough and sufficient enough, but it may be that the circumstances in your case, when you're conducting customer due diligence, you may find that it may be warranted to apply a lesser threshold. And if it's according to your RMCP and if it is justified to mitigate the risk, then you may do so. The 5% threshold recommended in PCC 59 is aligned with Regulation 32A in the Companies Act regulations, and the Companies Act regulations specifies that or directs that an affected company must establish and maintain a register of persons who hold beneficial interest equal to or in excess of 5% of the total number of securities of that class of securities issued by the company, and the register must speak in one of the official languages of the Republic, and it must record certain information. So, for example, if it's a natural person, the full name, date of birth, identity number, if it's a South African citizen. If it's not a South African citizen, then the passport number, the passport's country of issue, and country of birth if non-South African. If it's a juristic person that owns those shares, then the full name and registration number of the juristic person, residential and postal address. So there's a whole bunch of information that's required in terms of this regulation to properly disclose the beneficial interest. Accountable institutions are advised when applying the threshold approach, please conduct a holistic ownership assessment. So what this means is if there are multiple layers in your structure, if you find that your structure is a complex structure and you find that legal persons across the board actually they look like they own small percentage of a legal ownership interest, but when you look across the board and you look across all the layers involved in your complex structure, you see they actually accumulatively hold the more than the threshold amount, right? Which is known as parallel beneficial ownership structure. So when it's aggregated, when you take it in totality, it actually equals to 5% and more. So this is why you need to conduct a holistic ownership assessment of the legal ownership interest, because sometimes it may at face value look like this natural person only holds 3% of the structure. But when you look at the different entities and the different layers across the structure, you see that this person actually accumulatively and aggregate as an aggregate and in totality actually owns 10% maybe of the structure, and that would be your beneficial owner because they own 5% or more. So let's say you went through step one, right? You went through controlling ownership interest and you couldn't identify a natural person. You couldn't identify a warm body who meets the threshold, or there was a doubt about the structure. When you're conducting your customer due diligence, there is a doubt that was raised about the structure. Then you move on to step two. And step two asks us to look at a natural person, look for the warm body who exercises effective control in different ways, so through other means. And this list that's presented on the side comes from PCC 59. As I've mentioned, it is a long list, but it's not exhaustive. So an example of control through other means could include power of attorney, if there's a nominee shareholder arrangement at play, if there's delegations of authority, delegated authority in terms of law, power or influence to take decisions for a legal person or to veto decisions taken, so to reject decisions taken which impacts the profit of the legal person, court orders, etc. So if you can't find a person through controlling ownership interest, you look through control through other means. And if you can't find control through other means, then you look at your client and you go to step 3. And you look for the person who exercises control over the management of the legal person. So the day-to-day operations, who influences the decisions of the legal person. And remember, I mentioned, depending on the structure of the entity, this title may differ. So it's important to understand the legal features of your client, to understand the role players that are involved in your client. So it could be an executive officer, it could be a non-executive director, an independent non-executive director, a director, a manager, or maybe even a CEO. Specifically for trusts, and I did mention that legal persons, trusts, and partnerships, they are specific individuals that need to be identified as per the amendments to Section 21B through the General Laws Amendment Act. So for trusts specifically, it's not only the beneficiary of the trust that we look at or we identify as the beneficial owner, because beneficiaries are not the only persons who gain benefit from the trust. Depending on how the trust is structured and the purposes for which the trust has been created, a trustee or a founder may also have the capacity to gain benefit or to derive benefit from the trust. So you need to identify as an accountable institution per Section 21B. You need to identify all these natural persons linked to the trust, and those persons are your trustees, so all your trustees, your founder or your donor, settler, or protector, depending on the language used in that trust, the named beneficiaries. If the beneficiaries are not named, then how will those beneficiaries be named, or how will those beneficiaries be identified? You need to identify the mechanisms and the particulars of how those beneficiaries will be determined. If your trustee, founder, or named beneficiary is not a warm body, is a legal person, then you would go through the process of elimination and you would identify it as you would with any legal person. So you would look at the legal person, identify who is that beneficial owner, who's the warm body behind the structure, identify who acts on behalf of that legal person, so who is that representative, and you would identify all the beneficial owners using step 1, step 2, and step 3 of the process of elimination. When we come to partnerships, you need to identify and take reasonable steps to verify and identify each partner within the partnership, regardless of any percentage of ownership. So this includes every member of a partnership income and died, so every silent partner, every anonymous partner in a partnership or a similar partnership. If it consists of legal persons, then you must again go through the step-by-step process of elimination. So you would identify the legal person itself who is the partner in that partnership, regardless of the percentage of ownership. You will identify the representative of that legal person who is acting on behalf of that legal person, and you will look through that person. You will look through that legal person, pierce the corporate veil, go through step 1, controlling ownership interest, step 2, control through other means, step 3, management of the legal person, using the process of elimination to identify the beneficial owners. When we come to nonprofit organizations, so this is a type of legal person that could be involved in your structure, that could be your client, you apply a similar approach as you would to trusts. So you would identify all the founders of the nonprofit organization, and you would determine who is responsible and who exercises management of the NPO. Where beneficiaries are named, you will identify those named beneficiaries, and if they are not named, then you need to identify the mechanisms as to how these beneficiaries will be determined. Sorry, 1 second. I just want to share my screen again. So sorry. Okay, I think you can see my screen now. So when the beneficiaries are not named, you will need to determine, is there a process, and what is that process? What does that process look like to determine who that beneficiary is when the time comes? The last piece of the puzzle as an accountable institution. So what is required of you? You need to establish and identify the beneficial owners. You need to verify the corporate structure. You need to understand the ownership structure, the basic legal features of your client. You need to understand the risk that is posed from the perspective of money laundering, terrorist financing, and proliferation financing. Of that client, and you need to pierce the corporate veil. You need to look through that client and identify the warm bodies. The last piece of the puzzle is you need to evidence that you have followed the process of elimination. So you as an accountable institution for each client, you've gone through step 1, step 2, step 3 as needs be, and you've identified who the warm body is.